If you are a naturalized U.S. citizen, this update directly affects you, and ignoring it could be a serious mistake. I'm Michael, and welcome to Michael Visa Guide. In 2026, the Trump administration has intensified immigration enforcement in ways that are raising urgent questions inside immigrant communities across the country. We're seeing renewed denaturalization investigations, expanded background reviews, and literally thousands of older citizenship files reportedly being re-examined by federal agencies. So the big question that many people are asking me right now is incredibly simple but deeply important. Can citizenship actually be taken away? Let's slow this down together and separate fear from legal reality, because what you're about to learn could protect everything you've worked so hard to build in this country. Since returning to office in January 2025, President Donald Trump has made immigration enforcement his absolute top priority. Executive directives have focused on stricter compliance checks, massively expanded fraud detection efforts, and deeper reviews of past immigration records than we've seen in years. By early 2026, federal agencies began pouring more resources into reviewing naturalization histories, particularly targeting cases where there were potential inconsistencies, criminal omissions, or suspected misrepresentation during the original application process. The scale of this operation is unprecedented, and it's creating anxiety in communities nationwide. Now, before panic spreads any further through your community, here's what you need to understand immediately, and I want you to really hear this. Citizenship in the United States is protected by the Constitution. It is not something that can be canceled casually or on a whim. It absolutely cannot be revoked through a simple administrative decision made behind closed doors. It cannot be taken away without formal legal action in federal court. But, and this is where the nuance becomes critically important, there is a legal process called denaturalization, and understanding exactly how it works could be the difference between peace of mind and unnecessary fear. Denaturalization is not new. It has existed for decades under federal immigration law, sitting there in the legal code, available but rarely used. What has fundamentally changed in 2026 is the level of enforcement attention and investigative activity surrounding it. Resources are being allocated, cases are being opened, files are being reviewed. And this is exactly where misinformation online is causing massive confusion and genuine panic in immigrant communities. Social media posts are claiming mass citizenship cancellations that simply aren't happening. WhatsApp groups are circulating rumors about targeted nationalities without any factual basis. Headlines are using dramatic, fear-inducing language without ever explaining the actual legal framework that governs these processes. That is not how the system actually works, and I'm going to show you exactly what the real process looks like. Under federal law, the government can pursue denaturalization only if it believes citizenship was obtained unlawfully or through willful misrepresentation of material facts. That means fraud, deliberate concealment, false testimony under oath, identity deception, or eligibility that never legally existed at the time citizenship was originally granted, and even then, the burden of proof sits entirely on the government. This requires a formal lawsuit filed in federal court. It requires substantial evidence. It requires full judicial review, and the individual has the absolute right to legal representation and a complete defense. There is no secret administrative shortcut that bypasses these protections. None. However, what is genuinely new in 2026 is that enforcement agencies are now using far more advanced data cross-check systems than ever before. Older applications from the 90s, from the 2000s, are being digitally compared with criminal databases, international travel records, asylum files, and historical immigration documents that were previously stored only on paper. Cases that may have slipped through decades ago because of limited technology are now incredibly easy to flag with modern database systems. Files that once sat untouched in storage facilities are now searchable in seconds. That technological shift is exactly why older cases are suddenly being flagged more easily than before. But here's what's crucial to understand. Flagged does not mean revoked. Even if a case raises questions or inconsistencies appear in the system, the government cannot simply cancel citizenship administratively with the click of a button. It must file a lawsuit in federal court. It must present clear and convincing evidence to a judge. and the individual has the full right to defend themselves with experienced legal counsel. There is no overnight cancellation mechanism, no matter what you might be reading on social media or hearing in your community. So who is actually at risk? That's what I'm going to break down next, clearly, legally, and without exaggeration. Because the truth is this: for most naturalized citizens who followed the law and were completely truthful during their process, there is no immediate danger. Your citizenship is not under attack simply because enforcement has intensified. But there are specific categories of cases receiving renewed scrutiny in 2026. And if you fall into one of those categories, you absolutely need to understand exactly how this works, what triggers an investigation, and what your rights are throughout the entire process. Let me be very clear about something important. Not all naturalized citizens are being reviewed. Not all cases are being reopened, and there is absolutely no blanket policy targeting people just because they immigrated from a specific country or speak a particular language. What is actually happening in 2026 is far more specific and far more technical than the rumors suggest. Federal enforcement is concentrating on cases where citizenship may have been granted based on information that was false, incomplete, or intentionally hidden at the time of approval. The focus is not on what someone did after becoming a citizen. The focus is entirely on what happened during the immigration and naturalization process itself. That distinction changes absolutely everything about how you should understand your risk level. Denaturalization does not happen because you speak your native language at home. It does not happen because you travel abroad to visit family. It does not happen because you commit a minor traffic offense after becoming a citizen. It centers exclusively on whether citizenship was lawfully obtained in the first place, based on the information provided during your application. Right now, the cases receiving renewed scrutiny fall into very specific categories, and I want to walk through each one so you can honestly assess where you stand. One major group involves individuals who allegedly failed to disclose serious criminal history that existed before they naturalized, especially offenses that would have directly affected their eligibility for citizenship. We're talking about convictions that would have made someone inadmissible or ineligible, not minor infractions. Another category includes identity inconsistencies, situations where different names, birth dates, or background details appear across various immigration records, asylum files, or foreign documents. Sometimes these are innocent explanations, cultural naming practices, clerical errors, but they trigger review because the system flags them as potential fraud indicators. Marriage-based green card cases are also under review in certain instances. If permanent residency was originally obtained through a fraudulent marriage, meaning the marriage was entered into solely for immigration benefits, and that status later led to citizenship, those files can attract serious attention from investigators. There is also examination of cases involving undisclosed affiliations with prohibited organizations, terrorist groups, or criminal enterprises that could have made someone inadmissible at the time of application. These are the categories being actively investigated. But here is where fear often completely replaces facts, and I need you to understand this distinction. Not every mistake on a form qualifies as fraud. Not every forgotten detail is grounds for losing citizenship. The law requires that any misrepresentation be material, meaning it must have been significant enough that if the truth had been known at the time, citizenship would not have been granted. A typo in an address is not material. A forgotten short trip abroad that you simply didn't remember to list is not material. A minor traffic citation that you paid and forgot about is not material. Intentional concealment of eligibility blocking facts, lying about criminal history, using a false identity, those are what matter under the law. What has truly changed in 2026 is not the law itself. The legal framework remains the same. What has changed is the level of review and the technology behind it. Federal agencies are using advanced digital cross-check systems that compare decades-old applications with criminal databases maintained by the FBI, travel records from Customs and Border Protection, immigration filings stored across multiple agencies, and other federal data sources that were never connected before. Files that once sat in paper archives in warehouses are now digitized and searchable in seconds. That technological shift is why older cases are being flagged more easily than before, why someone who naturalized in 1998 might suddenly receive questions about their application in 2026. At the same time, new naturalization applicants are experiencing significantly longer processing times and far more detailed interviews than in previous years. Officers are asking deeper questions about immigration history, employment records, travel patterns, and prior filings. Requests for additional evidence have become much more common. People are being asked to submit documents they never had to provide before. This heightened scrutiny during the application process has created real anxiety in many communities, but that is actually different from retroactively stripping citizenship from people who qualified lawfully years ago. If you were honest during your process, met all requirements, and had no disqualifying issues at the time of approval, enforcement intensity alone does not place you in danger. The law still protects you. However, if you are aware that certain facts were never fully disclosed, if you used different identities during different parts of your immigration journey, if you have unresolved concerns about your original eligibility, 2026 is absolutely not the year to ignore those uncertainties. A private consultation with an experienced immigration attorney can provide clarity and genuine peace of mind, because when it comes to federal immigration law, uncertainty is manageable with proper guidance. Silence and avoidance are not. Now let's talk about something most people never think about until it's too late. What actually happens if you receive a notice? If you are ever contacted by a federal agency questioning your naturalization, the most important thing to understand is this: you have rights. Strong ones. Constitutional ones. The government cannot strip citizenship through a phone call. It cannot revoke it through a letter alone. And it absolutely cannot demand that you prove your innocence without following strict constitutional procedure. If authorities believe there was fraud in your naturalization process, they must file a civil lawsuit in federal court. That is step one, and it's non-negotiable. Without a federal court case, there is no denaturalization, period. And once a case is filed, you have the right to respond. You have the right to hire an attorney, and I strongly recommend you do so immediately. You have the right to review every piece of evidence against you. You have the right to challenge that evidence. You have the right to present your own defense, your own documents, your own witnesses. And the burden is entirely on the government to prove its claim with clear and convincing evidence. You do not have to prove you deserve citizenship. The government must prove you never lawfully qualified in the first place. That's a heavy burden. If you are contacted informally, whether through a letter requesting information or an unexpected visit from an investigator, you are not required to answer detailed questions without legal representation. You can politely state that you would prefer to consult an attorney before responding to any questions. That is not an admission of guilt. That is not suspicious behavior. That is exercising your constitutional protection. And any competent attorney will tell you that's exactly what you should do. Another key point: denaturalization cases are civil proceedings, not criminal ones. That means the standard of proof is high, clear, and convincing evidence. But it is not the same beyond a reasonable doubt standard required in criminal trials. However, if fraud is alleged in the denaturalization case, related criminal charges could potentially follow in separate proceedings. Immigration fraud is a federal crime. That is why legal guidance from the very beginning is absolutely critical. You need someone who understands both the civil and potential criminal implications. You also have the right to appeal. If a federal court rules against you, the case does not automatically end there. You can take the matter to a higher court, to the Circuit Court of Appeals. The appellate process exists precisely to ensure that errors are corrected and constitutional protections are preserved throughout the legal system. And here is something many people do not realize. If the government attempts to denaturalize someone for a specific allegation and fails to meet its burden of proof, it cannot simply keep retrying the same claim repeatedly without new evidence. The judicial system is structured to prevent abuse of process and protect individuals from endless harassment. Now let's address something emotional but incredibly important. Receiving any communication questioning your citizenship can feel absolutely overwhelming. It can feel deeply personal. It can feel like everything you built over years, over decades, is suddenly unstable, like the ground is shifting beneath your feet. But fear is not strategy. Panic is not a plan. The United States operates under a constitutional framework. Judges review evidence. Courts impose standards. Executive agencies cannot bypass that structure simply because enforcement priorities shift with a new administration. We have already seen immigration policies challenged in federal courts throughout 2025 and 2026. Some measures have been limited by judges, others have been blocked entirely or put on hold pending further review. That process of checks and balances continues to function. Courts are still independent. Judges still make decisions based on law, not political pressure. And that matters enormously. If you are a naturalized citizen who followed the law and completed your process honestly, enforcement intensity alone does not erase your constitutional protection. That protection remains intact. However, if you ever receive official correspondence related to your citizenship status, the absolute worst decision you can make is ignoring it. Silence does not make legal matters disappear. It can actually make them significantly worse. Deadlines matter. Response times matter. Prompt response, professional representation, thorough documentation review. That is the formula for protecting yourself. One of the biggest rumors circulating right now is that naturalized citizens are being mass deported in 2026. That is not accurate. Denaturalization cases, even with increased enforcement, represent a very small fraction of the millions of naturalized citizens living in the United States. These are targeted legal actions based on specific allegations of fraud, not a broad sweep against immigrant communities. The numbers are still relatively small compared to the total naturalized population. Another claim you may have seen online is that speaking your native language, traveling back to your home country, or maintaining dual citizenship can put you at risk. That is completely false. The United States does not require cultural abandonment as a condition of citizenship. You can speak your language. You can visit family abroad. In most cases, you can hold dual citizenship if your home country allows it. None of those activities automatically trigger denaturalization. That's a myth being spread by fear. There is also significant fear around criminal conduct. Here's the legal reality, and please listen carefully. Once you are a naturalized citizen, crimes committed after naturalization generally do not make you deportable. Citizenship changes your legal standing dramatically compared to being a green card holder. Deportation is a consequence for non-citizens. A citizen cannot be deported unless citizenship is first legally revoked through the court process we discussed earlier. The only time criminal issues become relevant to denaturalization is if they were concealed before or during the naturalization process and would have affected eligibility at that time. Timing matters, disclosure matters, context matters. Another rumor suggests that certain countries are being unofficially targeted for citizenship review. There is no public law or official directive that strips citizenship based solely on national origin. That would be unconstitutional. Enforcement cases are supposed to be evidence-based, not ethnicity-based. While certain regions may face heightened scrutiny in broader immigration policy discussions, denaturalization requires individualized proof tied to a specific person's application history, not their country of origin. Now let's talk about something more subtle. Increased interview intensity for new applicants has led many people to believe that previously approved citizens could automatically be retested or re-interviewed without cause. That is not how the system operates. Naturalized citizens are not randomly called back for interviews just because standards have evolved. A case must have a trigger, an inconsistency discovered, an investigative lead, or documented evidence that raises a legal question about eligibility at the time of approval. Fear often fills the gaps where clarity is missing, and in politically charged environments, rhetoric can sound much broader than the actual legal framework allows. It's also important to understand that executive enforcement priorities do not override constitutional safeguards. Courts remain a powerful check on federal authority. Throughout 2025 and 2026, multiple immigration-related directives have faced legal challenges. Some have been narrowed by judges. Others have been delayed or blocked. That judicial oversight is part of the system working as designed. That doesn't mean enforcement efforts are symbolic. They are very real. Investigations are real. Scrutiny is higher than it's been in years. But legality still governs the outcome. If you obtained your citizenship lawfully and honestly, there is no automatic countdown clock attached to it simply because the policy tone has changed with the new administration. However, staying informed is not optional. Laws evolve, regulations shift, enforcement priorities adjust. Understanding the difference between political messaging and enforceable law is what protects you from unnecessary panic. So where does this leave you in 2026? Not in panic, but in preparation. If you are a naturalized citizen who followed the law, disclosed your history honestly, and met all eligibility requirements at the time you applied, your citizenship remains one of the strongest legal protections available under U.S. law. That foundation has not changed, but being protected does not mean being careless or ignoring practical steps you can take right now. The first practical step is simple. Organize your records. Keep copies of your naturalization certificate, your green card history, your original applications, and any supporting documentation you submitted during your immigration journey. Digital backups matter. Paper copies matter. If questions ever arise, documentation becomes your strongest ally. I recommend creating a complete immigration file with everything organized chronologically. Second, if there were complex elements in your past immigration process, such as prior visa overstays, criminal charges that were resolved, name variations, or previous filings under different circumstances, consider scheduling a confidential review with an experienced immigration attorney. Not because you are necessarily in danger, but because clarity removes uncertainty. An attorney can review your entire immigration history and tell you honestly whether any red flags exist. Third, respond promptly to any official correspondence. If you ever receive communication from a federal agency referencing your naturalization, do not ignore it. Do not assume it's an error or that it will go away. Do not attempt to navigate it alone without professional help. Early legal guidance can prevent small issues from escalating into major problems. Now let me speak directly to green card holders watching this. Permanent residents do not have the same constitutional shield that naturalized citizens have. Your status can be revoked more easily if serious violations occur, if you commit certain crimes, if you abandon your residence. That is why maintaining compliance is absolutely critical. File taxes consistently every year. Avoid criminal conduct entirely. Maintain continuous residence in the United States. And apply for citizenship as soon as you are eligible. Citizenship is not just symbolic, it is structural protection. The difference in legal protection between a green card and citizenship is enormous. For those currently on the path to naturalization, increased scrutiny in 2026 does not mean the door is closed. It means preparation matters more than ever. Be thorough with your application. Be accurate with every detail. Disclose completely, even things you think might not matter. Small omissions can create unnecessary complications in an environment where review standards are significantly tighter than they were 5 or 10 years ago. Looking ahead, enforcement intensity is likely to remain high throughout the remainder of the Trump administration. Additional executive actions could emerge. Regulations may continue to evolve. Legal challenges will likely continue moving through federal courts. Immigration policy in America has always moved in cycles throughout our history. Enforcement expands under some administrations. Courts review those actions. Political winds shift with elections. Legislation stalls in Congress. Reforms resurface years later. But throughout those cycles, one principle remains consistent. Citizenship law operates within a constitutional framework. Executive authority has limits defined by the Constitution. Courts impose standards. Due process exists for a reason. Do not let political noise convince you that protections have vanished. At the same time, do not ignore the reality that compliance matters more now than it did years ago. Technology has improved dramatically. Data systems are integrated across agencies. Historical inconsistencies are easier to detect. Preparation is power. Knowledge is stability. If this breakdown helped you understand what is actually happening under the 2026 immigration enforcement landscape, share it with someone who needs clarity instead of fear. Many people in your community are reacting to headlines without understanding the legal structure behind them. Make sure you subscribe to Michael Visa Guide for continued updates because I'll keep bringing you clear, factual information as policies develop throughout 2026. And if your situation is complex, consult licensed immigration professionals who can evaluate your specific case because no online video can replace individualized legal advice tailored to your circumstances. Most importantly, remember this. Millions of immigrants have built stable, successful lives in the United States. Naturalized citizens continue to vote, work, raise families, start businesses, and contribute to every part of American society. Enforcement cycles may shift with different administrations, but lawful citizenship remains one of the strongest legal statuses in the country. Stay informed, stay prepared, and I'll see you in the next video.